statement. A written statement is a statement of defense to be filed by the defendant. And when it comes to a civil suit, a plaint will be submitted by the plaintiff, about which we have covered in the last session. And once a plaint is submitted in a court of law, a notice will be sent to the defendant about the allegations made against him by the plaintiff. And after carefully reading this plaint, a written statement is prepared by the defendant, and this statement of defense is submitted to the court. And this written statement is by a way of reply to the allegations made by the plaintiff in the plaint. And it is covered under Order 8, Rule 1 of the Civil Procedure Code. Now let us see the drafting of a written statement. Order 8 provides for the filing of a written statement, all the details to be contained in a written statement, and the manner of doing so. So before drafting the written statement, it is very essential from the part of the defendant to go through the plaint thoroughly, and not at all the content of the plaint. He has to go through all the documents submitted by the plaintiff with the plaintiff in support of the claim. And after a thorough study of the plaint and supported documents, a para-wise answer or a paragraph-wise answer of the plaint can be prepared by him. And there is a time limit for this. Order 8 of the CPC deals with the written statement, set off, and counterclaim. So the time given to the defendant to file a written statement is within 30 days from the date of service of summons on him. So the court of law will send a summons to the defendant, and from the date of service of the summons on the defendant, 30 days time is given to file the written statement. And if it is not filed accordingly, he can be allowed to file the written statement on some other day as specified by the court, and the reasons for allowing such a date should be recorded in writing. Anyway, the written statement shall not be later than 90 days from the date of service of the summons. So you can delay maximum up to 90 days, within which anyway you have to file the written statement. Usually within 30 days, if it is not filed in 30 days, court may give another date, but it cannot be beyond the 90 days of service of the summons on the defendant. Then let us see the contents of a written statement. And the introductory paragraph of the written statement refers to all the allegations and averments contained in plaint as to their specified denial or admission as the case may be. So what is to be written as an introductory paragraph is the defendant specifically denies all the allegations and averments in the plaint except to the extent as are expressly and specifically admitted thereunder. So from your part, when you are admitting something, you have to clearly mention which paragraph you are admitting. And then if you are denying something, you have to clearly mention what paragraph you are denying. So you are reading the plaint, finding out what all admissions are there and what all denials are there. And once you admit or deny, you have to clearly mention the paragraph which you are admitting or denying. And otherwise it will be taken as you are admitting everything. Then you have to write it like this. The allegation in para dash of plaint denied. It was agreed with the amount stated in the plaint may be, and the defendant is not liable to pay amount with interest. That depends upon the cases. When a problem is given related to an amount, you can write like this. What you have denied, you have to mention, and then a brief description of the reasons by which you are denying it. Then admissions and denials and defenses. It is stated in written statement through paragraphs, distinct and consecutively numbered paragraphs. So when you are mentioning the paragraphs, it is distinctly numbered 1, 2, 3 like that. And specific admission you can make, like paragraph dash is admitted, just like I have already told. Then specific denials also can be there. The averment contained in para dash of the plaintiff is false. Then you can have dilatory pleas like a preliminary objection. There can be some objection which is connected to this plaintiff. First of all, you can see that this, first of all, we can see this example. This suit is not maintainable because it is barred by Limitation Act. So the specific problem which is given to us, you have to check whether the date is within the Limitation Act specifications. For example, in the case of a money suit, you will be getting only 3 years time to file a suit. Then the remedy is barred by the law. That's the purpose of the Limitation Act. So if that particular plaint is falling within this category, you can simply write it as the suit is not maintainable because it is barred by Limitation Act. So you need not answer to the question which is put by the plaintiff. Then there can be objections like limited legitimacy of the person or the plaintiff, disqualification from inheritance of the plaintiff, then incapacity, remoteness of damages, want of notice, etc. In certain cases, to provide notice is essential, especially in negotiable instruments related cases, check cases. If notice is not given, it means that you cannot file a suit. So such a thing can be put as a preliminary objection by the defendant when he is submitting his written statement. So first of all, you have to remember when you are reading the plaint, if it is falling within any of these categories, you can put a preliminary objection. You need not answer other points which are told by the plaintiff. Then there can be set off money from plaintiff. Defendant can plead set off in case of mutual creditors or mutual debtors. What does it mean? Suppose the plaintiff is owing 50,000 to the defendant, and the plaintiff is claiming 1 lakh from the defendant, asking that the defendant has to pay him 1 lakh. That time what the defendant can tell is 50,000 may be set off against the claim made by the plaintiff. So the defendant need to give only the balance of 50,000. 50,000 already he has returned to the plaintiff. And depending upon this, a counter claim also can be filed by the defendant. That is a file, he can file a suit against a claim of plaintiff. Example, set off. Then there can be special defenses like transaction is void or voidable, misrepresentation of the parties, etc. Then there are certain things in a contract which is affecting the free will or free consent of the parties. The consent can be made or the consent can be affected by the use of some force, physical or mental force. That time the contract will become either void or voidable. And misrepresentation is one of the examples for that. There can be fraud, mistake, things like that. So these are coming, falling under the category of special defenses, which you can mention in a written statement. Then you have to be careful about the list of documents, valuation, etc. So this is all about the written